Good morning, everybody, and welcome to our webinar. My name is Jessica Blumenthal, and I'm a director in the ENS Africa Banking and Finance Department. This webinar is the first in a series of webinars presented by our department to assist our clients and our friends with their continuous professional development obligations and responsibilities. So because this is a CPD accredited webinar, if you are hoping to claim CPD hours from attending this webinar, please make sure that you've given us your ID number. Some of you would have done that during the RSVP process, but some of the attendees we can see from our records have not done that yet. I'm going to just share a slide quickly with everybody. There we go. So if you've not yet provided us with your ID number, please do email the email address that you can see on your screen now. And Talia will make sure that we have all the information that we need to be able to issue your CPD certificate to you for having attended this webinar. Please also importantly remember that in order to qualify for the CPD hours, you need to stay on the webinar until the end. We do have to pull the stats, and we can only issue certificates to those who've been on the webinar for the full time. So that's the housekeeping and the admin out of the way. And so I'm going to hand over now to my partner, Era Gunning, who is our POPI expert and who has been working tirelessly to make sure that everybody understands POPI and what's coming. So let me hand over to Era for what I'm sure will be a very interesting webinar today. Thank you, Era.
Thank you very much, Jessica. I am absolutely delighted to be speaking to you about one of my favorite topics, the Protection of Personal Information Act today. POPI is an incredibly interesting piece of legislation, and I'm very glad that I've got Jess on the line. If you guys raise phase questions that I can no longer answer, I used to deal with phase a couple of years ago, but these days my main focus is POPI and FICA. So thank you very much for joining our session today. If you do have any questions, please, this should rather be a workshop than a lecture, so just interrupt me at any stage. We will also do Q&A at the end, but as we go along, I will pause and I will ask you if you have any questions, so please do raise any questions that you may have. So yes, as you know, we are going to be discussing the Protection of Personal Information Act. I still call it POPI. About 11 years ago, when it was still a bill, 12 years ago, we all used to call it POPI, but I know these days they call it POPIA and the POPIA Act and POPIA, and the regulator calls it POPIA. And I think she says she prefers us calling it POPIA because it's similar to, or POPIA, bear with me, she calls it POPIA because she says we should call it by a name similar to its sister act, the Promotion of Access to Information Act, PIA. So I still call it POPI, but whatever you call it, it is all the same thing. It is our legislation that deals with the protection of our personal information. It is also our privacy legislation. In South Africa, it's our data protection legislation. So I'm going to discuss the general application of the Act with you today, the role players, the role of the information officer, which I know everybody has been panicking about because we need to get them registered, the processing conditions, trans-border transfers, prior authorization. I know quite a few of my clients have been worried about this as well, given the timelines. We're going to discuss direct marketing, data breaches, a POPI checklist. What is the minimum must-haves that you must have in place by 1 July, non-compliance, and of course, Q&A throughout. So we've got a lot to cover, but hopefully it is going to be fun. So first of all, where does POPI come from? Now, in 1980, the OECD guidelines on privacy came out. And that was basically the genesis of privacy legislation and privacy principles as we know it. That led to the EU Directive on Data Protection, which came out in 1995. And you may be aware, about 3 years ago, in May 2018, that was replaced by the EU General Data Protection Regulation, or the GDPR. So basically, the OECD guidelines would be seen as POPI's grandmother. The EU Directive is POPI's mother. The GDPR is POPI's sister. So not surprisingly, POPI says that when you interpret the Act, we must interpret it in a way to give effect to these international standards. I mention this now because throughout today's session, I will be referring to overseas standards. So POPI became a bill in 2009. It eventually became an act in 2013. And since then, we've been waiting for our president to announce the commencement date. That happened in the middle of COVID last year on the 1st of July, 2020. The majority of the provisions commenced, but most of them are not effective yet. And everybody, including financial services providers, we're given a 1-year period before we have to comply. But by 1 July, that period runs out. I'm often asked if this is going to be extended. I really don't think so. The regulator has made it very, very clear that they are ready for this act to commence. When they were criticized because it kicked in during COVID, they said, but we've been telling you for the last 7 years at least, it's been coming. You were supposed to be preparing. So I definitely do think that it is going to kick in on the 1st of July. And by then we will all have to be POPI compliant. So we've got less than 60 days left. So the next question for consideration is then, when does POPI apply? POPI applies when you process personal information which is entered into a record in South Africa. So our activities need to happen in South Africa, but we don't care whether the person to whom that information relates is in South Africa, is a South African citizen, an illegal immigrant, sits in the USA, sits in the EU, sits in Rwanda, or for that matter, sits on the moon. We care about the fact that a person's personal information is being processed in South Africa and there is some sort of recording going on. So that recording could, for example, be taking notes, taking video, recording a session on Zoom or MS Teams, or making any other copies of that information. So we need a record and we need processing of personal information in South Africa for POPI to apply. So it is obviously important that we work out what is meant by the processing of personal information. So the next thing that we are then going to consider is what is meant by personal information. And as it would, my slides are not moving, they have frozen. So I'm quickly going to stop sharing and then I'm going to reshare and hopefully that is going to be sorted out. There we go. Yes, and it's working. Yay. Okay, so we're going to look at what is meant by personal information. Can you just confirm that you can see my slides, Jess?
Yes, Era, I can. Thanks.
And they are on the personal information slide?
That's right.
Awesome, thank you. Okay, so we're going to look what is meant by the definition of personal information. What is meant by the phrase personal information? So in section 1 of POPI, you'll get this definition of personal information, and it includes things like race and gender, sex, pregnancy, education, medical, financial, criminal history, employment history, any identifying number, a symbol, an email, biometric information, and so on and so on. So we've got this whole list of things, but it is important to note that the stuff on the list is merely information. It is just data. The way we turn it into personal information, which triggers the application of the Act, is to make it related to identifiable persons. So the minute the stuff on the list relates to an identifiable person, that is where ordinary information or data becomes personal information. Now, who is this identifiable person? Now, this is very interesting. So in terms of POPI, this person can be a living natural person, so any human being, provided that human being is alive, or an existing juristic person, as far as is applicable. Now, why do I say this is interesting? Now, in the other countries, also based on the OECD guidelines, also based on the EU directive, so where we have sisters, like under the GDPR, they all only recognize human being data subjects. We are the only country of which I'm aware, and I've looked at about 50 countries now, that recognize juristic person data subjects as well. So whereas in the rest of the world, they recognize human beings as being protected, South Africa also protects juristic persons. And the reason for this is because we also give effect to our constitutional right to privacy. Now, if you studied law, then you will know that Section 14 of the Bill of Rights gives us the right to privacy, and the Bill of Rights applies to human beings and to juristic persons as far as is applicable. So this is why we are different to the rest of the world. Now, I often see when we're dealing with the likes of European clients or European companies or service providers, then they generally think because they comply with the GDPR, they're complying with this gold standard. So their law must obviously be stricter than ours, more stringent than ours, but that is not the case, because very often we need to amend their standard agreements, for example, their standard processing agreements, because we note that these processing agreements are not POPIA compliant because of the juristic person element. I note that somebody in the chat has said, I've heard that Colombia also protects juristic person information. Thank you for that. I'm actually going to look that up. So thank you very much for that. I haven't heard that before. Okay, so, but we will get back to the other questions in the chat as well. I am not skipping you. I will look at them every now and then. Okay, so now I said personal information is information relating to an identifiable person. But POPIA recognizes two broad categories of personal information. We get the stuff that I've left in black, and that includes some pretty sensitive stuff. It includes things like my name and my contact details, my financial history, my criminal history. But I've left it in black because in terms of POPIA, it is classified as ordinary personal information. So it is classified as ordinary personal information, and that means that as a general rule, we can process this information even without consent from the data subject. So even without consent, provided we've got a lawful purpose to process that information, then we don't need consent from the data subject. What would be lawful purposes? Lawful purpose would include it is necessary to pursue my legitimate interests. It's necessary to pursue your legitimate interests. We'd be giving effect to a contract, such as a contract of employment or a mandate, or we're doing it because a law says we must. For example, FICA that says we must conduct CDD on our clients. We're doing it because FICA says we must. So we don't need data subject consent there. But the minute we hit the other type of information, which I have marked in red, which I call the red flag information. POPIA has a special definition for it later on in the Act in Section 26. POPIA calls it special personal information. Then our lives become a whole lot more difficult. So, for example, information relating to your religious or philosophical beliefs, race, ethnicity, trade union membership, your health, sex life. Criminal behavior, if it goes to the alleged commission of an offense, yeah, this guy hasn't been found guilty. We think he has done something wrong, or any proceedings in respect of the alleged commission of an offense. The minute you hit this type of information, your life becomes a lot harder because now the rules change. And as a general rule, here you would need consent to use the stuff. There are obviously exceptions. The most notable one is information can be processed when a law says we can process it. So, for example, race information can be processed for BBBE reasons. We can process it in terms of the Employment Equity Act because there's a law that says we must. Health information, you know that your health information is being processed left, right, and center at the moment because of COVID reasons. And we can do that because our disaster management regulations say we must, and the Occupational Health and Safety Act says we must process health information to curtail the spreading of the pandemic. So, but generally, unless there's a clear-cut law or we've got data subject consent, be very, very careful when you process special personal information. Likewise, information of children, kids under 18, next of kin, beneficiary information. You may be doing sponsorships or you may be handing out bursaries. If you're dealing with kids under 18, their personal information is basically personal information on steroids. It then includes all of their information, the black stuff and the red stuff. General rule, don't touch it without the guardian or the parent's permission. So don't process this information without consent. Of course, there are exceptions, but then you need to go and look for those exceptions. Something like legitimate interests by itself would not be enough. Just to go to the chat quickly, how will we handle personal information of a juristic party which is already available in the public? And I've got that from Roanne. Roanne, that is such a good question. Now, often I'm asked if when information is in the public domain, does POPI stop applying to it? Absolutely not. So when information is in the public domain, either I've made it public, for example, I've put it on Facebook or Instagram or LinkedIn or some social media, or it's available on a public register, such as the SIPS register. POPI still applies completely to that information. So all you need to do is go and search for the words made public in POPI, and you will see that POPI applies to it completely, but there's a bit of lenience. So for example, lenience that we see is in Section 12. Section 12 says generally we must collect data from or personal information from the data subject itself. But if the data subject made it deliberately public, we can go and get it from another source. Likewise, if you go and look at the special personal information sections and you look at the children's information provisions in POPI, then you will see you can process that information if it has been made deliberately public by the data subject. So this is not, for example, when the paparazzi took photos. So this would be me making it deliberately public, volunteering that information. So POPI does apply to it, including to publicly available information of juristic persons, but a bit of lenience as to how we can deal with that information. And then another question here from Lorato, how do we identify personal information in relation to juristic persons? Lorato, this is such a difficult question and we get this all the time, and it is like trying to fit a square peg into a round hole. Because generally, if we battle to interpret POPI, we go and look at international standards. But of course, now we can't find any international standards. Apparently, maybe something in Colombia that I want to look at. So we can't find any international standards dealing with juristic persons. So we don't know. And last week, we actually had a webinar where we also discussed with our IP department what would be the intersection between IP laws and POPI. So you would see, for example, a symbol of a juristic person is personal information, but that may very well be a trademark. So any stuff on this list that could relate to a juristic person like a company could potentially be personal information. We do find that when it comes to our red flag information, our special personal information, generally that type of information would not be, special personal information would generally not relate to companies, except for alleged criminal proceedings. You could have a company committing offenses. So to cut a long story short, anything on here that relates to an identifiable juristic person would be seen to be personal information if the circumstances so dictate, but generally with our red flag information, it would not be seen to be juristic person information would generally not be caught there. And then if we have security video footage of a crime, can we share the images with other security forums without consent? I would be incredibly nervous to do that, because here you are dealing with information of an alleged criminal activity. Nobody has been found guilty yet. So you are dealing with special personal information, red flag information. Generally, don't touch the stuff unless you've got consent. And does an emergency situation warrant not obtaining consent from the data subject for special personal information? Not particularly. So if you go and look at the GDPR, they refer to public interest and being able to process personal information in public interest, including special personal information. We don't have those exceptions in terms of POPIA, which again makes your special personal information so difficult to deal with. Last question from Jessica before I move on. Jessica says, will information on its own, such as a vehicle number plate, constitute personal information? Yes, fantastic question, Jessica. So if you look at this list, as I've said before, generally you need something on this list, and this is not a closed list, or it needs to relate to, sorry, I said there's something on this list, but it needs to relate to an identifiable person, and the list is not a closed list. Now, if you look at something like an identifying number or telephone number, I certainly think that there is room to argue that a license plate number or a telephone number by itself, if you don't have other blocks of the puzzle to identify that information, I certainly think we can argue that for a while it is not personal information. It may become personal information when we identify the person behind the telephone number. But I think if you've got random numbers, random registration numbers, and you don't have the keys to unlock those details, I think we can argue that it is not personal information. But be sure that you do not have the keys to unlock that information. And then, Peter, just to answer your question before I move on, in terms of an alleged crime, surely we can provide that information to the police and so on. Absolutely, we can provide it to the police, because when you process personal information on behalf of a public body to prevent crime, such as on behalf of the police, then POPIA doesn't apply to it. Okay, so moving on. While we've got the slide on, I want you guys to have a look. There's something missing here, something that is glaringly missing when you see it the first time. So I'll give you 10 seconds to stare at this slide and to tell me if you can see what is missing here. So something that is clearly personal information, but it is not here. The missing element here is photos. You will not find a photo or an image in this definition, but clearly a photo or an image must be personal information. So I think a photo sits in biometric information. So biometric information is not defined in the Act, but biometrics are defined as when you use some sort of technique. So you use a technique, so that means there is some sort of technology behind it. So you use some sort of technique to analyze either physical or psychological or behavioral characteristics to at the end identify a person. And I think that's exactly what a photo does. A lie detector test does the same thing. It uses psychological features to help you identify a person. Certainly when you use facial recognition or voice recognition, that would constitute biometric information and special personal information. But I think a photo by itself could also be seen to be special personal information. So be very careful when you do use photos. And I mention this because we had so many questions now about CCTV cameras and sharing that kind of footage. So I just wanted to mention to you that if you use photos, please be careful. It is probably special personal information. And if you do go to the GDPR, you will see that the GDPR now specifically says photos, facial images would constitute biometric data. And you will see that I'm playing around with my screen here because, again, I've got some sort of glitch where the screen doesn't want to move. Hopefully it's going to move now. And let me quickly just start the slideshow again. There, it's moving. Sorry for this. I think we've all been there in an online world. Okay, so we discussed personal information. Now let's discuss the processing of personal information. When will we be processing personal information? Processing is absolutely anything with a verb, anything that you do with personal information. So when you collect information, you receive it, you record it, you organize it, whatever you do with personal information would be seen as the processing of personal information. So processing, often asked, so come 1 July, will POPI apply to our old personal information? Absolutely. POPI is going to apply 100% to any information that you already have in your possession because you would be storing it. And this is not retrospective application. POPI simply says from 1 July onwards, if you're doing anything with personal information, including storing it, then you need to do it in a POPI compliant manner. So very important that you know that anything that you do with personal information would be seen as processing. And when POPI kicks in, it will apply to your old data. Now, I often see that my clients get some sort of emotional attachment to old CVs and the like, employee information. So they keep old CVs, even if they don't employ a person, and they say to themselves that we're going to start a talent bank and maybe we'll employ them in future. Huge risk when you do that because you need to keep that information updated in terms of POPI. And I'm very sure you don't do anything to keep old CVs updated. You're supposed to keep that information secure. And often we see cyber attacks are against old information, and then we don't know how much information these cyber attackers have gotten hold of. And also you have to attend to data subject access requests. So very important that before POPI kicks in, you do some sort of privacy impact assessment or POPI audit to check what data you no longer need and that you do get rid of that information before POPI kicks in. So just to check a few other questions here, FICA is obviously one of those acts which allows you to share information without consent. Yes, it just depends on what you mean by sharing that information. So Gillian put up a question here that FICA allows you to share information without consent. Not share it with random people, but for example, share it with a FIC, absolutely, when you do a suspicious transaction report or something like that. And FICA certainly does allow you to also collect information without consent. One or two more questions. Is getting consent from the data subject enough to get their medical information from their doctor, and can a doctor refuse to provide an FSP with this information? I'm going to answer you in terms of POPI. In terms of POPI, yes, consent would be enough, but I'm not sure if there's any health legislation or medical laws that would stop the doctor from providing that information, because obviously they are also subject to confidentiality provisions. But from a POPI perspective, when you've got the data subject consent, it's enough from a POPI perspective. What would your comment be relating to calls being recorded in the normal course of business? When you're recording calls in the normal course of business, I urge you to get consent to do so. So if you read RICA and FICA together, RICA says that you can record, monitor communications if it's for business purposes, but generally as at the least you need to let your employees that you know that you are monitoring these communications, and monitoring includes interception and recording and so on. But to cut a long story short, if you read POPI and RICA together, I would certainly recommend that you do get consent. Now, this is a good time to stop and focus on what is meant by consent. Consent in a POPI world must be voluntary, so I must have a real choice. It must be specific and informed. So I must understand what you are doing with my information. And very important, there must be an expression of will. Consent does not have to be in writing, but we need an expression of a will. We need a positive action to show that we consent. It could be a signature, but it could also be my action. And if you do record calls, instead of those, the standard disclaimer in the beginning of a call that says this call may be recorded for quality control purposes, I would suggest that you rather say, by continuing with this call, you agree that we may record it for quality control purposes or whatever else you're using it for, or you could also refer people to the likes of a privacy policy that is readily accessible. Okay, so we'll look at some more questions just now, but just a little bit in the interest of time, I'm going to move on. Okay, so POPIA applies when we process personal information, and I actually don't believe this, but these slides are again not moving. So here we go again. There's definitely some sort of ghost in my machine today. And we're on processing. Let's see if that works. There we go. Okay, who are the role players in terms of POPIA? And I just noted that I had a question about operators and responsible parties. It was a very good time to ask that question, because here we're dealing now with responsible parties versus operators. So in terms of POPIA, we get various role players. We get our data subject, who, remember, can be a human being or it can be a juristic person like a company. So our data subjects are those persons whose personal information would be protected in terms of POPIA. They can be your employees, they can be clients, human beings or juristic persons. They could be other FSPs. They could be business partners that you are dealing with. So any person whose personal information you are processing is called a data subject. Then we get the responsible party, who is generally our FSP. So the responsible party is called a data controller overseas, and that is that entity who decides to process personal information. It is the entity who decides what information to collect, why to collect it, what to do with that information, and so on. So called the controller of the data overseas. They decide, I call it the boss of the data in my head. They decide to collect the personal information in the first place. Every single responsible party must have an information officer and may appoint deputy information officers. I'll get back to that soon as well. Now, POPIA realizes that the responsible party can't do everything itself. So very often you would get an operator to process personal information on your behalf. You could, for example, appoint an administrator just to do administrative tasks on your behalf. You could also use the likes of Metrofile to store information, a cloud services provider, an HR company, a recruitment company, a payroll company. So where you use a third party, not an employee, to process personal information on your behalf, then that person is known as an operator. An operator is called a processor overseas. But the problem we have in terms of POPIA is that the operator has got very few duties and obligations in terms of POPIA. In fact, all they need to do is keep the information confidential and let you know if there's a data breach, and only use the information for purposes that the responsible party knows about. Now, if the operator doesn't stick to these duties, there are no sanctions in terms of POPIA. So very light regulation of operators in terms of POPIA. But now when we get to the responsible party, POPIA warns the responsible party. And POPIA says, responsible party, be careful. You're handing over your precious data to an operator. And an operator would be like your arms and your legs. If the operator messes up, in terms of POPIA, it is as if the responsible party has done so. So POPIA says, be careful. At the very least, enter into an agreement with this operator where you tell them to keep your data secure. We often add other stuff to these agreements, such as indemnities and warranties, and give us our data back at the end of our agreement, or destroy it, and audit rights and sub-operators and so on. But POPIA says, as a very minimum, we need to include security measures in our agreements. So very important that you go and revisit any agreements that you may have with any entities that process personal information on your behalf. And if you are still going to have this relationship come 1 July, then you need to enter into operator agreements with them. Lastly, we've got the information regulator, headed by Advocate Pansy Takula, and their term is already coming to an end at the end of, or in the beginning of December. Then they would have been in their position for 5 years already. Okay, so as you may be guessing, these slides again are not working. And here we go again. Okay. In the meantime, while I'm fixing these slides, I've got a question from Audrey. Audrey says, can a data subject, and Audrey, I've lost your question here. Let me put it up quickly. Can a data subject, a juristic person particularly, provide their data for processing for the data themselves to be the responsible party? For example, the data subject does not want to provide their consent to the bank unless the bank agrees to process the data as an operator. No, I'm not sure I understand what you're saying, but you cannot contractually force a person to be an operator if they are not an operator, Audrey. So a person would by their nature be an operator, and the likes of a bank would generally not be an operator. The bank would itself be a responsible party. So very often we find situations where we have more than one responsible party. And in terms of the GDPR, they refer to them as joint controllers. So not in every single situation where we share information with a third party, would that third party necessarily be an operator. So very often we share information with other entities who would also be responsible parties. Let me give you an example. If you share information with the likes of a law firm is generally seen to be its own responsible party, just like also information shared with banks. Generally, unless for some reason they're just doing some sort of mechanical task on your behalf, they would be seen to be their own responsible parties. Okay, and we'll get back at the end. Hopefully we've got some time, and then we'll carry on and taking questions on the operator. Okay, so there we go. Okay, so now we're going to discuss the role of the information officer. And I've already said to you that every single responsible party in South Africa must have an information officer. But it's not even every single responsible party in South Africa. It is every single entity who processes personal information in South Africa and makes use of some sort of automated means. And if you look into the history of those provisions, you will see it catches just about every single offshore responsible party that does some sort of information processing in South Africa. So if you are an entity and you control personal information in South Africa, or you use operators in South Africa, and you process personal information in South Africa, you have to have an information officer. Your information officer is by default the CEO. The CEO can appoint somebody else, authorize somebody else. The regulator is of the view that even if the CEO authorizes somebody else to become the information officer, the CEO remains liable for non-compliance. The CEO or the information officer that gets appointed by the CEO may then appoint deputy information officers. Now, your deputy information officers and your information officers must be registered with the information regulator. There are forms available on the information regulator's website. There's supposed to be a portal that opens up for these registrations. The portal was initially supposed to open up on the 1st of May, but they are experiencing glitches. So we'll see when that portal opens up. And I see somebody may try use arrows. Yes, I have been using the arrows, and the arrows are not making a difference, but thank you for that. Okay, so Section 55 of POPIA sets out the duties of information officers. Okay, so first of all, the first duty is to encourage compliance. So our information officer must encourage compliance, deal with requests made to the body in terms of POPIA, for example, data subject access requests, which we will discuss just now, working with a regulator as a point of contact, and otherwise ensuring compliance by the body with the provisions of the Act. So our information officer must be our point of contact for the regulator. And as I've mentioned, there is a portal that is supposed to be opening up. We could also email our registrations to the information regulator, but that email address has crashed at the moment as well. So they're experiencing all sorts of issues at the moment, but hopefully those will be resolved soon. Okay, so as far as our information officer is concerned, as I've mentioned, they're going to be the contact person for the regulator, and there are a few duties that have been prescribed in the regulations as well, which we are going to get to now. And those duties include a compliance framework that must be developed. So you must develop a compliance framework. What is a compliance framework? There is no definition in the Act for a compliance framework. So it is whatever you say it is. We use a compliance tracker, and we also use an Excel spreadsheet in this regard. We must do personal information impact assessments. Those are your POPIA audits. And I'm trying not to go into presentation mode because sometimes that stops these glitches that you experience when you present. We will be sharing these slides with you afterwards. So if you're battling reading them, don't worry, we are going to be sharing these slides with you afterwards. Okay, so another duty of our information officer is to develop processes and measures to deal with data subject access requests. And this is where a data subject comes to you and they want to access the information. You have to have a process in place to deal with that. Internal awareness sessions must be conducted. So training, the likes of what we're doing now, is mandatory, and you must have a POPIA manual. So you must have a POPIA manual, and it is one of the cases that can attract personal liability on the part of the information officer not to have a POPIA manual. So incredibly important that you do put a POPIA manual up on your website. Okay, so liability of the information officer. I know very often information officers are very reluctant to take on that authorization as information officer because they're worried about the personal liability that it may attract. And there is some scope for personal liability in the Act, but to be completely honest, you must do really silly things before you can be held personally liable. Personal liability would, for example, stem from you telling the company not to comply with an enforcement notice. So if the regulator were to issue a naughty notice against your company and you tell the company to ignore that enforcement notice, you can attract personal liability. You can also attract personal liability if you try and bribe the regulator or if you try and obstruct the regulator. So as I've mentioned, generally, you must do really silly things before there will be personal liability on the part of the information officer. But one that can easily attract personal liability is not having a POPIA manual. So please be sure to have a POPIA manual. If you have an existing POPIA manual, POPIA has amended POPIA, so make sure that you update your POPIA manual. And if you've got a website, make it available on your website. As I've mentioned to you already, the information regulators of the view that even if the CEO authorizes someone else to become the information officer, the CEO remains liable. We're not sure if that is the correct interpretation of the law. My view is if you authorize somebody, they step in your shoes, but where you delegate duties to deputy information officers, there you can remain liable for what you have delegated. But I think the point is a bit moot because, as I've mentioned, it would be difficult to attract personal liability as an information officer. Okay, I see we've got some Q&A questions and I'm going to get to them soon. I just want to start on the processing conditions. So there are 8 processing conditions. And if you are a responsible party, you have to comply with all 8 processing conditions. I often get asked, can you please in a paragraph or 2 tell us whether the following is POPIA compliant? It is never possible to opine in a paragraph or 2 as to whether something is POPIA compliant. So you have to always check each and every single processing condition. So we need to check each and every single processing condition, and there are 8 of them. And if we're dealing with transported transfers of personal information, there are extra requirements. If we're dealing with special personal information, there are extra requirements. So let's look at the 8 processing conditions. The first one is accountability. You as an FSP must comply with POPIA, and you need to be able to demonstrate your compliance with POPIA. How do you do that? You've got an information officer, you've got a data protection policy, you do internal awareness sessions, you've got a data subject access request policy, you've got a PIA manual, and so on. And later on in these slides, we will deal with the POPIA must-haves, those things that we must have in place by 1 July. Processing limitation, purpose specification, and further processing limitation all go hand in hand. We must have a lawful purpose for processing personal information. That lawful purpose could be, it's in my legitimate interest, it's in your legitimate interest, we're giving effect to a contract, or a law such as FICA says we must do it. But remember, when we are dealing with special personal information, then we need something extra. So we must have that lawful reason for processing personal information. And then we must process only as little information as we need to fulfill that purpose. For every single data field that you ask people to complete, you need to be able to justify why are you asking for that information. So don't ask for information you don't need. If you ask for information or you process information that you don't need, then you are excessively processing personal information. Only keep your information for as long as you are lawfully allowed to keep that information. When are you lawfully authorized to have information in terms of POPIA? If you've got data subject consent, you can keep that information, even indefinitely, but that consent can be withdrawn. If there's a law such as FICA or FAIS that says you must keep that information, then you must keep that information. And if you've got a lawful business purpose to keep information, you can also keep information. So I know in terms of FICA and FAIS, we must store our information for 5 years. Please be mindful of the provisions of Section 24 of the Companies Act. Now, Section 24 of the Companies Act basically says, if you are a company and there is some sort of law, including the Companies Act, that says you must keep information, then you must keep that information for at least 7 years and longer if that other law says you must keep it for longer. So in terms of FICA and FAIS, it's 5 years, but the Companies Act makes that 7 years. And the last processing condition here, further processing limitation. Any further processing of personal information, anything that you do with personal information after collection must be compatible with the reason why you collected that information in the first place. So don't go and do stuff with personal information that is not similar enough to the reason why you collected it. Then you are processing information further, and it may be incompatible with a reason for collection. Just quickly going back to the chat. Someone here says, Audrey says, Era, there's also a penalty when processing financial information recklessly. I think this is contained in the regulations. That's recklessness, possibly not having processes and policies. Absolutely, Audrey, I agree with you. And in terms of PIA itself, if an information officer does anything that is grossly negligent, there is scope for personal liability. Agree with you, not having policies and processes in place may very well be seen as gross negligence or recklessness. And then Jeff has asked, where can one get hold of the templates guidelines for a POPI manual? What you would have to do, there's no specific template or guideline yet. We can, of course, provide you with one at a charge, and I'll give you information about our POPI offering after the session. But there was an old POPIA guide published. It is unfortunately outdated. Our information regulator is supposed to bring out a new guideline, but that is not available yet. So if you look at the guidelines that are available generally on the internet, they may very well, and most of them are outdated. So if you use an old guideline, please read it with a schedule to POPI, because the schedule to POPI makes some changes to PIA. I see there are some other questions, and we'll get back to them hopefully just now as well. Okay, so we are on the processing conditions. We've discussed the first four processing conditions. Now we're going to discuss the second four. Information quality. You, as an FSP or any responsible party, must take reasonably practicable steps to make sure that the personal information in your possession is up to date, accurate, and not misleading. So this is information of any other FSPs you may deal with. It's information of your clients, it's information of your employees, it's information of your services providers, your suppliers. So very important that any personal information that you have in your possession, you put procedures in place to update that information. This could be an email once a year, asking people or companies to let you know if the information has changed. It could be as simple as printing a poster and putting it on bathroom doors and telling your employees, if you're not working remotely, that please remember, if your personal information has changed, you must let us know. Openness. Now, openness says you need to tell the data subjects about certain things. You need to tell the data subject who you are with your contact details. You need to tell them what information you collect. Why do you collect that information? Who do you share that information with? Do you send that information overseas? And you even have to tell them that they can go to the information regulator if they want to fight with you. So very important that you have a privacy statement in place. Privacy statement is sometimes called a privacy policy or privacy notice. If you've got a website, put it on your website. And in all your data subject facing documents, your supply agreements, your tender documents, your onboarding forms, any application forms you may have, any mandates, include a reference to your privacy statement. And that is how you notify your data subjects of these mandatory things that you will find in Section 18 of POPI. Security safeguards. You need to implement reasonable technical and organizational measures to make sure that the personal information in your possession is secure. The technical stuff is the IT stuff, firewalls and passwords, and you may always get those passwords, those reminders that tell you to update your passwords. Incredibly, incredibly important, because that is necessary as a technical safeguard. Organizational safeguards are your common sense measures. So if you are going to use a lockable cabinet, make sure the cabinet is in fact lockable. Make sure that you do go and file your hard copies of information, and that you give keys to the cabinet only to people on a need to know basis. Data subject participation. Our data subjects have certain rights in terms of POPI. Our data subjects can come to us free of charge and ask us what information they have about us. Against a prescribed fee, which is very low, they can ask for copies of their information, and they can even, worst case scenario, exercise their right to be forgotten. And that is where they say to us, delete the record of my personal information. I don't want you to have any of my personal information anymore. But that right is not absolute. It must be weighed against the FSP's right to have that information. So for example, if somebody owes you money, you don't have to forget about them. I would love to tell my bank to forget about my mortgage, but they never listen. So, of course, your right to be forgotten is not absolute. It will be weighed up against the responsible party's rights to have your personal information. So, let's look at a few questions before we move on. I've got a question here from Peter, and Peter says, the privacy statement, do you need to send it to all your customers, or is it good enough to have it on your website? It depends, Peter. If you make changes to it or it's a new one, it would be better if you send it to everybody, but that might just not be possible. It might be too expensive, and then you would make it available on your website. Generally, it's good enough to have it on your website and to reference it in terms of all your other data subject-facing documents, so that you don't have to email it to them if it is readily available on your website. So our law recognizes something called the doctrine of incorporation by reference. And that means we could, for example, hyperlink a privacy statement in our other documents, such as our onboarding forms. And as long as that hyperlink actually works and your privacy statement is readily available, it is in simple, understandable language, then it should be okay just to have it on your website. Okay, let's go through a few additional questions. Can you please provide clarity as to the definition of a responsible party and an operator in terms of POPI? That was an early question and we did deal with that. But basically, to recap, your responsible party is that person who decides to collect information, why to collect it, what to do with it. They are in control of the personal information. They are the boss of the data. And your operator is somebody who processes personal information on the responsible party's behalf. I understand that the privacy statement must be displayed at the point of a data collection, say a store. Then can this be displayed on a still slip or website link, or must it be in a format of a poster at the store? Larry, POPI doesn't address that at all, but what POPI does say is it must be readily, or it does say you must give notice in a reasonable manner to your data subject. So it depends on your custom. So in some circumstances, it may, where you know, for example, people don't have access to websites or they don't have data, then it wouldn't work to give them a link to a website that they can not access. So it really does depend on your clientele, the demographics, and so on. But POPI doesn't say where it must be. It must just, notice must be given to the data subjects. Then, anonymous attendee, do you believe that the FSCA itself will have to review certain information made available to public in light of POPI regulations? For example, sensitive information, tribunal cases, outcomes are made public. Is this not regarded as special personal information? No. A tribunal case's outcome would not be seen as special personal information unless it includes some alleged behavior. But generally, if there is some finding, then it is no longer alleged. But would the FSCA have to change their practices? Well, they have to be POPI compliant, and I haven't done an audit on them to check if they are POPI compliant. So the FSCA would have to be POPI compliant. And one last question before I move on. How can a call center continue to call consumers from 1 July? Oh, we're getting to that one. We're getting to that one soon. And must the CAO also apply, or just the delegated IO? It is the delegated IO. And delegated is, strictly speaking, not the right word. We should be calling it the authorized IO. So your CEO is automatically appointed as your information officer. If he or she authorizes somebody else, then that person must be registered with the regulator. If he or she does not appoint somebody else, then it would be the CEO that must be registered. But there is no form to authorize the CEO. The CEO is automatically the information officer, but he or she can authorize somebody else. But CEO must, unless they authorize somebody else, be registered with the regulator. I hope that answers your question. Okay, we'll look at some more questions if we get time. Just now, I'm going to deal with trans-border flows of information now. So POPI says a responsible party, such as an FSP, in the Republic, Now, this is the only provision that actually says our responsible party must be located in South Africa. So this provision is not going to apply to a foreign responsible party. POPIA says a responsible party in South Africa must not send information overseas or trans-border unless you put at least one safeguard in place. So you must have at least one safeguard in place. So obviously this applies to multinationals or making investment overseas and sending information overseas, cloud computing transactions, but it even applies to an email that you send out of South Africa containing personal information. You have to put at least one safeguard in place. So the various safeguards, I'll look at a few of them, is you can send information overseas if the third party is sitting in a country with adequate data protection laws. Now, the problem we have with adequate data protection laws is that it would only work for human being information. So juristic person information, no other country except I'll go and have a look at Colombia, recognizes juristic person information, so we can never rely on adequacy of a law when we're sending juristic person information overseas. But if we are sending human being information overseas, to my mind, we can rely on the countries that have been declared to have laws adequate vis-a-vis the GDPR. And you can simply Google GDPR adequacy decisions, and you'll find a list of countries that have been declared adequate. But our regulator has recently at a webinar said, according to her, no other country is adequate. So we'll have to see if they issue any guidance on what they see to be adequate. But I see no reason why for human being data, we can't rely on countries adequate vis-a-vis the GDPR. If you can't rely on a law, you can rely on binding corporate rules. Now, binding corporate rules is a group data protection policy. So this group data protection policy applies to a group of companies, and it is the only lenience in POPIA for sending information to or for processing information in a group of companies. So you can, if you have binding corporate rules, you can send information to other entities in the group. And a binding corporate rules are it would simply just be a global data protection policy that recognizes the principles in terms of POPIA. Or you can enter into a binding agreement. Now, a binding agreement is very similar to what they call the model clauses under the GDPR. A binding agreement, we call it a trans-border transfer agreement, and that is an agreement that you then enter into with a third party to make sure that they will treat the data contractually as if they fall under POPIA. You can also send information trans-border if the data subject consents to such transfer. There are a few others, like giving effect to a contract and so on, but I'm not going to go over each one. You will be given a copy of the slides. What I want to get to is prior authorization. So prior authorization, in terms of section 57 of POPIA, if you do one of the following four things, one or more of the following four things, then regardless of data subject consent, regardless of privacy statements and compliance with all the processing conditions, you have to go to the regulator and ask for permission to continue doing the following. So this is a form that you fill in, you submit it per email to the regulator, and you ask the regulator to authorize this type of processing. And I'll go over them with you quickly. The first one is if I process any unique identifiers. Now, a unique identifier is something like an ID number, or possibly somebody's telephone number, something that is uniquely linked to a specific person. And I take that unique identifier for a purpose other than the reason why I collected it. And I go and mix it with another responsible party's data. We call that data matching. and we need permission from the regulator to do that. Let me give you an example. You take contact tracing details that you collected for COVID purposes, and you go and take that data and you go and mix it with another entity in the group's data. And you say to that other entity in your group of companies, check if these guys are your customers already. We've got this list of contact details. If they're not your customers, then add it to your database and go and send direct marketing to them. Now, there are lots of POPI issues there, but one being you're now taking a unique identifier, using it for a purpose other than the reason why you collected it. You're mixing it with data of a third party. For that reason, you need to get prior authorization. You also have to comply with the processing conditions, and you're probably going to need data subject consent. But quite aside of the rest of POPI, you need to fill in a form and get permission to do this. If you process information on criminal behavior on behalf of third parties, so you're not doing it for yourself, you're doing it for other entities, you need to get prior authorization. So not if you do criminal checks on your staff. This is where you do it for other entities and you are acting as a responsible party. We sometimes see this in groups of companies where they have shared services, and shared services does, for example, criminal and background checks on behalf of staff, or you do sanction screening on behalf of other entities in the group. You would have to go and ask the regulator for permission. If you process information for the purposes of credit reporting, so credit reporting is very widely defined in the guidance note and certainly includes credit bureaus, but they'll be subject to a code of conduct. And if you're subject to a code of conduct, this provision doesn't apply. But it also includes credit providers. And I think it includes anybody else who reports on a person being a bad payer. If you do this, you need prior authorization. And you also need prior authorization if you're planning on transferring special personal information, your red flag information, or information of children under 18 to a country without adequate data protection laws. And I think that would generally be the countries that are not adequate vis-a-vis the GDPR. Let's quickly look at a few questions here. Okay, Kim, you asked, our employees are not necessarily contracted or employed under an entity, but under a group company. In order to register the IO, they need to be employed with that specific entity. How do we then register IOs if they are not specifically employed with an entity? This is very difficult, Kim. So this is the regulator's view versus what the law says. So if you look at POPIA, POPIA defines who your head of your company is, and POPI says it is the head that will be the information officer of a private body. And POPIA says you can authorize any person to be your IO. The regulators of the view that your IO must be an employee at exec level. The guidance issued by the regulator is just guidance. It can't change the law. And according to POPIA itself, it does not have to be an employee. Arnold, you've asked if we are part of a multinational group and we have binding corporate rules, would we still have to comply with the adequacy requirement in respect of juristic persons, as you have stated, no other country is deemed adequate? So what we generally do, Arnold, is if you have binding corporate rules for a multinational, and these have been drafted under the GDPR, then we add an addendum that deals with South Africa. And in that addendum, it's usually only 2 pages or so. We go and say, for South Africa purposes, if this data is being processed in South Africa, then we change the definition of data subject to include juristic persons. But then the binding corporate rules will be binding corporate rules for POPI purposes. And if the other entities in the group accept it under POPI, then you will be able to use your binding corporate rules. But we would then have 2 different documents after this amendment or this addendum. We'd have the GDPR one, which was approved overseas by supervisory authorities, and we'd have the POPI one. and the POPI one doesn't have to be approved by the regulator in South Africa. So it is doable, but you need to have an addendum. And then one more question here. If you process unique identifiers as part of your normal course of business, for example, an identity number linked to an insurance policy as an insurer, would you need prior authorization, or would you be safe if you only use it for the legitimate purpose for which you collected it? If you use it for the purpose for which you collected it, no issue. It is when you go and use it for a purpose other than the purpose you collected it for, and you go and mix it with identifiers of another responsible party. I'm well aware that we have more questions, and we'll try and get to them just now. As far as prior authorization is concerned, we also set out the process and the timelines in the slides. I would like to get to direct marketing now, and we had a question about that just now as well. So direct marketing in terms of POPI, huge headache. So direct marketing means I come to you, you don't come to me. So I approach a data subject, and I do this either in person, or I do it by mail or electronic communication, and I do it for the direct or indirect purpose of selling my stuff to you or asking you for donations. Then I'm doing direct marketing. So this is not where you come to my website or you come to my social media page. I come to you. And for POPI to apply, I must be processing some type of personal information when I come to you. So for example, let's say I do a pamphlet drop and I've got no personal information when I hand over the pamphlet to a stranger. POPI will not apply to that. We need to have some sort of personal information being processed for POPI to apply. Now, in a nutshell, if you do direct marketing, it is incredibly stringently regulated in terms of POPI. Now, these provisions are based on the EU directive, and we are far more stringent than the EU directive. So we say, if you do it by means of telemarketing, pamphlet drops, if you have the person's contact details and so on, or in person, such as when you send a representative to the person, broker or the likes, you can do it, provided you comply with the processing conditions, those 8 conditions, and if the person tells you to leave them alone, you must leave them alone. But the minute you do your processing, you send your information by electronic means, and your electronic means would be SMS, MMS, faxes, voice messages, automated calling machines, and so on. The minute you do that, POPI says the person must be your customer or you must have consent. To be a customer, you must have obtained contact details in the context of a sale, and you must have given the person an opt-out when you obtained their contact details. So a person is only your customer if in a POPI, if you told them that you are going to send them direct marketing and you gave them an opt-out. In a POPI world, if you didn't give them an opt-out when you collected their details, you cannot send direct marketing to them without consent. And the trick in terms of POPI is you can only ask them once for consent for this opt-in, and it must be in a prescribed manner and form. So overseas, consent must just be express. So a general tick box would suffice, but in a POPI world, it's not good enough. Your consent must be similar to Form 4 in the regulations. So very, very strict requirements when it comes to opting in. And I'm going to finish the slides. We're almost done, and then we'll go back to questions because I'm sure there might be some direct marketing questions. Security compromises in terms of POPI. In terms of POPI, a data breach is called a security compromise. And POPI says, where there are reasonable grounds to believe that personal information of a data subject has been accessed or acquired by an unauthorized person, then you must tell the data subjects and the regulator as soon as reasonably possible. We've got no threshold. And interestingly enough, The only other country that I can find without a threshold is Turkey. So in terms of the GDPR, you only have to report breaches if there are reason to believe that it will lead to substantial harm to human beings. So if there's a likelihood that there could be substantial harm to human beings, like their banking details were compromised, then you have to make that notification. In terms of POPI, a little breach, like losing one document with personal information, is seen in the same light as a massive cyber attack. So in terms of POPI, they must all be reported to the regulator. We raised with this with the regulator. We said, how are you going to cope? And they basically said, well, we will decide what to investigate or not. You must report all these breaches to us. The regulators of the view that these provisions have already kicked in. So if you do suffer security compromise, please note that the regulators of the view that these must already be reported. And we can certainly help you with those reports. Just a POPI checklist, the must-haves. What would be the minimum that you would have to have in place come 1 July? You have to have an information officer who is registered with a regulator. And we said that's automatically the CEO. You must make certain mandatory notifications to your data subjects, which you would be doing in a privacy statement. You have to have a POPI compliance framework. You have to have a data protection or POPI policy. You have to do privacy impact assessments. We usually do POPI audit questionnaires and create a gap analysis. You have to have a PIA manual. You have to have a data subject access request policy when people or companies want to access the information you have about them. You must do POPI awareness and training. You must enter into those mandatory agreements with your operators. And in some instances, we've mentioned them, you would have to go and ask for prior authorization from the regulator. So there are loads of nice to haves in terms of POPI, but these are the must-haves. And together with these slides, after today's session, we will also send you information on our POPI toolkit, which is basically a set of documents and policies that you need to fast track your compliance. Non-compliance with POPI, any person can run to the regulator. It could be your competitor. It doesn't have to be a person who has suffered harm. The regulator can try and secure a settlement. If no settlement is possible, the regulator can start an investigation. And if a breach is found, the regulator can issue an enforcement notice, a naughty notice. From a civil side, the data subject or the regulator can sue the responsible party for damages. Your criminal sanctions for non-compliance with an enforcement notice or bribing the regulator and so on range between 12 months to 10 years in a nice South African jail, or 10 million rand, or both. And from a civil side, we're not sure what sort of amounts will be awarded, but POPI recognizes damages for patrimonial and non-patrimonial loss. So money for monetary loss and money for non-monetary loss, such as emotional loss, anxiety, defamation, shock, and so on. POPI also speaks of aggravated damages, and that's presumably a lot of money if you've been very naughty. And that is the end of the slide. So now I can stop sharing and let's have a look at some of the questions that we have. What is your proposal on dealing with, for example, sales managers who receive business cards from customers with no further discussion? Can the details be shared with the rest of the sales team or organization? How can an organization ensure that the information is retained properly when the organization is not aware of it, or the business card may be left at the employee's home or car? Okay, so it would be important to give guidelines to your staff on business cards and so on, but it's important to know that POPI only applies to non-automated information, such as business cards, if it's not been entered into a computer system, if it is supposed to form part of a filing system. So if you were never supposed to add this to a filing system, if it's just a business card that you chuck in your handbag and that is the end of it, a good argument can be made that POPI doesn't apply to it at all. But then those business cards are also largely useless. So I would say, I would suggest here that you do just set some simple rules that if you get a business card, you enter the details into the system. And I do think that you can share it with other entities in the group, or no, other entities within the same responsible party, not other entities within the group of companies. I think that would be further processing that is incompatible. So your question here would be, would giving that business card to somebody else be compatible with the reason for collection? It depends on the circumstances. Why did that person give you the business card? So if the person gave you the business card just to get back to them about a certain issue, then sharing it would be incompatible. But if they gave you the business card, like often at ENS, we get contact details and they say, please add us to your marketing list, or we want to receive new newsletters, then the sharing would be permissible. Very, very fact specific. And I would suggest that you just set simple rules in this regard. Can a responsible party indemnify the information officer against personal liability? In this regard, you can get certain types of insurance, but you can never indemnify anybody against a criminal sanction. So we can get certain indemnities, but not against a criminal sanction, which is problematic. But like I mentioned to you, I think it's hardly ever where we're going to seek criminal sanctions. Can a responsible party keep data indefinitely in order to protect from legal liability in future? Yes, if strict requirements are met, and there's a lot of risk when you keep information indefinitely. If you keep information indefinitely, you need to have processes in place to keep that information updated. You need to have that information safe and secure. So there is risk involved, but a short answer is, if you can justify that you've got a lawful business reason to keep it there, yes, you can. And also, if you've got consent from the data subject, you can keep that information indefinitely, but that consent can be withdrawn. So yes, you can, but the answer is never so short. You would have to demonstrate that you comply with all the processing conditions. I've got a question here. Just want to know when the slides will be sent to us. It will be sent to you in the next day or two. Is there an exemption for POPIA manuals? Yes, there is an exemption, but that exemption will expire at the end of June, presumably as POPIA kicks in, the POPIA exemption will stop being enforced. So from 1 July onwards, we think everybody is going to need a POPIA manual. Let's see if we can answer one or two more questions. Would a responsible party be required to obtain express consent from all its data subjects prior to performing a disaster recovery test where the data center is located in a different country? Some of the information would be children information. Oh, this is very, very interesting. So you would have to check exactly what information you have. When it is children's information, you should presumably already have guardian consent or parental consent to be processing that information. You would have to check your consents. What did your consents say about processing that information? Very, very fact specific. Very difficult to answer this without the facts. But definitely, if you're processing children's information, red flag information, you have to go back to your consents, your original consents, to see what they say. Would you need prior authorization for sanction screening if it's a regulatory requirement? If you're doing in a shared services in a company, for example. Mary Ann, I'm so glad you raised this because I actually wanted to mention it to you today. My view is for sanction screening, always get consent because you hit alleged criminal behavior. So as you know, FICA says you need to do sanction screening if you enter into a business relationship with a person and you are an accountable institution, such as most FSPs. So then in terms of FICA, you must go and do a sanction screening. And then POPIA Tara says to you, don't deal with people who have been sanctioned. But the problem is POPIA Tara that must be read with FICA only recognizes our UN sanctions. So generally, if you perform sanction screening, you go way beyond the UN list. You do OFAC checks. You may screen against Her Majesty's list and so on. So the minute you're now going beyond the local legal requirements, then you are now dealing, or you may deal with special personal information. and it's not a clear-cut requirement in terms of our law. So I would certainly suggest that you do build in consents to do that. And there was already a case overseas in Sweden, the GE Health case, where the company tried to rely on legitimate interests under POPIA sisters, very similar legislation, to justify sanction screening, and they failed. They weren't allowed to do that. They said your legitimate interests do not override the data subject's legitimate interests. So definitely, I do feel very strongly about that. Sanction screening, unless you're an accountable institution and you're just purely screening against the UN list, very advisable to get consent. I don't have access to the clause, but it says transfer is for the benefit of the data subject. Yeah, absolutely. So this anonymous, the clause you're looking for sits in section 72. So in terms of section 72, you can also transfer information overseas if it's for the benefit of the data subject. And I think it says something like, in the data subject, it's not reasonably practicable for them to consent in the circumstances, but they would have probably consented if you gave them a chance to do so. Yes, so anonymous, you're looking for section 72, and it relates to transporter transfers of information. I've got another question regarding the exemption for POPIA manuals, and I've told you that that expires. It is not practical to obtain consent to the transfer. It were reasonably practical to obtain consent, the subject would be likely to give it to us. Can we rely on this if the processor cloud provider is in the US? Very, very much depends on the circumstances here. Generally, data transfers to the US are seen to be red flag, because they don't have adequate data protection laws. So generally, we like to rely on a transport or transfer agreement here, or you go and look at your cloud provider standard T's and C's, and you check whether they are good enough. Do they give the protections that we would like in terms of POPIA? And I think, we've got 3 minutes left. A common way of generating business is via referrals from satisfied clients, in which the advisor may contact a prospect or referee with a view to offering services. Your comments, please. Giovanni, if you're going to be doing this, I would suggest that you do it in person, or you do it by means of telephone, because telemarketing and sending a person to go and chat to these people in person would not be as regulated as sending emails and SMSs. You wouldn't trigger those horrible Section 69 provisions. The only thing you would battle with is being able to demonstrate that the further processing is compatible with the reason for collection. But there, I think you could also argue your reason for collection was to contact them. So in a nutshell, I think you can go and contact prospects by means of telephone or in person, obviously if you make appointments and so on, but be stately or of direct market, electronic direct marketing, you will fall foul of the act if you try and do electronic direct marketing. Will we be in breach of POPIA if we have a number of subsidiary companies processing personal information, but we have only registered the parent with a regulator? Our advisor has told us only the parent needs to register. Apologies, with all due respect, I don't agree with that. Every single subsidiary is its own responsible party. Every single entity in a group of companies, it's its own responsible party. It is not the registering of the subsidiary that is the issue. It is the fact that each one is a responsible party and must have an information officer that needs to be registered. So it's not the company that must be registered, not the FSP itself. It is any entity who processes personal information in South Africa that would have to register an IO. And guys, I've answered as many of these as I possibly can, but we are out of time now. My contact details will be sent to you. So if you do want to contact me afterwards, only with pleasure. Thanks so much for attending the session, and sorry for the technical glitches that we had in the beginning. The slides will be shared with you, and we will also tell you about our POPIA toolkit, and my contact details will be shared with you. Thank you so much for joining the session and enjoy the rest of your week. Goodbye.